Hey, thank you very much. It is such an honor to be back here with SAGE, and I want to thank Sue Morris and also Lori Wendell for all the efforts that you do locally here and nationally for SAGE. It is a great honor to be back to do the Supreme Court update and federal litigation update. And while I'm only talking about one or two cases this year, it is mile deep in terms of complexity and importance. So I'm very pleased to be here, but unfortunately with COVID, we have to do so many things by Zoom these days. And our lives really changed in March. And I do want to express just some condolences and mourning right now as we continue to lose colleagues, friends, and loved ones to COVID. I just found out about another client and colleague who passed away yesterday. So it's all touching us, and it's impacting all of our lives, and it's also impacted the Supreme Court practice, including the McGirt versus Oklahoma and Sharp versus Murphy cases as well. I'd like to dive right into the cases, and I think it's particularly appropriate for Native American Heritage Month to talk about McGirt and its impact. Basically, the questions that I'm going to try to focus on today are the overview of McGirt, understanding what the Supreme Court decision means, and also what it means for tribal governments, the federal government, and the state government, the relationships going forward. First, I want to say that I believe that McGirt and Murphy are the most important cases in Oklahoma history. Second, I believe that they're probably the most important federal Indian law case or cases in several generations for a lot of reasons. And I think that really these cases were not cases that tribes sought to bring, but rather through circumstance of two criminal defendants seeking to modify their sentences and their adjudications in state court, tribal sovereignty got swept up into it. And I think that highlights some of the important aspects of this case to talk about. Most certainly, as soon as the McGirt decision came out on July 9th, I printed it out immediately and started digging into it, and life has really changed since then. It's been quite a whirlwind. It's a really thick opinion, but one of the best that I've read in many, many years. And I think that Justice Gorsuch's majority opinion will be quoted and cited for many generations to come. If you've not read it, I really recommend that you actually pull it down and take a read. It may take you several hours to go through it, but it truly is a tour de force of history, of treaties, of federal Indian law, and just really wonderful prose that Justice Gorsuch wrote in crafting this opinion. But I do make clear that it is a 5-4 decision, and Justice Gorsuch was actually the junior member of the court, but was assigned by the senior member of the majority, Justice Breyer, by custom to write the opinion. But that was good for good reason, because Justice Gorsuch came from the 10th Circuit, where he was a judge for about 2 decades, and is a Westerner from Colorado, and had really developed quite an expertise on federal Indian law. And I think for the times to come, the justices on the Supreme Court will regularly look to Justice Gorsuch for his experiences and wisdom as a leader in federal Indian policy. Federal Indian law can be very difficult for members of the court. And if you've read history of the Supreme Court justices, such as the Brethren, written probably 4 decades ago, they write about how difficult and how those decisions can go back and forth, and how many justices tried to avoid authoring federal Indian law opinions because they involved so much history and so much swinging and changing congressional statutes and federal policy. But this really is a landmark case, and I wanted to just talk about some more detail. The basic holding of the case is that the Muskogee Creek Nation reservation remains intact. It's the treaty reservation from 1866, and it's never been abolished by Congress. It unseats a long-time myth in Oklahoma that has weaved its way into Oklahoma case law and popular belief that reservations cease to exist at statehood. McGirt sets that on its head. It also has great practical importance immediately with criminal jurisdiction and who will try the criminal cases. Is it going to be the federal government? Will it be the state government? Will it be the Muskogee Creek Nation? Or will it be a blending of several of those? It basically adjudicated the Indian Country statute, which is known as the Major Crimes Act, 18 United States Code, Section 1151, and cleared up a lot of confusion that was there for Oklahoma. It's also important to the other 573 or so federally recognized Indian tribes and Alaska Native groups in the United States because it marks a shift in textualism in the Supreme Court of recognizing and affirming that the text of treaties matter, that the text of statutes matter, and the extra textual considerations such as the passage of time, demographics don't necessarily matter when the statutes and the treaties are clear. Now, the term reservations was actually not mentioned in the Muskogee Creek Treaty of 1866. And it wasn't mentioned in the similar treaties that were also passed at that time period that involved the other so-called 5 tribes, the Choctaw, the Chickasaw, the Cherokee, the Seminole Nation, who had very similar treaty provisions. But we will likely see that the other 4 of the 5 tribes will have similar treaty rights affirmed soon through various court actions. We've seen cases percolating in state district courts and the Court of Criminal Appeals for Oklahoma that will adjudicate some criminal cases based upon those treaty languages. And also there are criminal cases that are also pending in Oklahoma that involve citizens of other tribes that have treaty provisions, which tribes are studying and claiming that their reservations also have not been disestablished. So this is a landmark case. It's also been cited by another circuit court in north of us, involved in the Oneida Nation. I believe it's the 7th Circuit, if I recall correctly, in a case this summer that cited McGirt for the proposition that the Oneida Nation's reservation had never been disestablished. That particular case involved basically a zoning and regulatory dispute about the Oneida Nation and a local government. But we're not going to see the end of McGirt, and it will continue to be very active. And I'm sure that Ambassador Chowdhury will discuss Creek Nation's approach to McGirt. But McGirt is not just McGirt versus Oklahoma, but it also merits mention the case that led up to McGirt, and that was Patrick Dwayne Murphy. Patrick Dwayne Murphy committed a heinous murder in 1999 along a rural McIntosh County road within the Creek area. And he brutally murdered another Creek citizen, George Jacobs, and left him to die on the side of the road after he mutilated him. And shortly thereafter, McIntosh County state of Oklahoma prosecutor picked up the case, tried it in McIntosh County about 4 to 6 months later. He was convicted by a jury there, and he was condemned to death by that jury. And he went to Big Mac Penitentiary in Oklahoma, where he subsequently mounted a number of legal challenges, both through the Court of Criminal Appeals, but also through federal district court. In all, Patrick Dwayne Murphy had 7 different cases in 4 different courts, including the Eastern District of Oklahoma Federal Court, the 10th Circuit, Oklahoma Court of Criminal Appeals, and several state courts to challenge his conviction. His theory of the case changed during the time period, but initially he claimed that because where the murder allegedly took place, because it was on a former allotment that still had restricted mineral interests, I believe 1/12 mineral interest, that qualified that particular area as being Indian country under the Indian country statute, 18 United States Code Section 1151, under the allotment statute. But there were a lot of tribal nations that saw this and were dubious, and I was one of them at the time when we were asked about amici participation in the case, because we thought that that's a case with pretty bad facts, and case that the courts probably wouldn't buy that a 1/12 mineral interest was enough to constitute Indian country on a former allotment that had lost all of its other restrictions. So the federal public defender who was assigned to the case, I believe it was Lisa McCollum, fought vigorously to explore the reservation theory and Indian country theory to defeat state court jurisdiction. And basically, the strategy was to prevent Mr. Murphy from being put to death under Oklahoma's death penalty. And she worked the case for a number of years. Unfortunately, she passed away in 2007. Thereafter, a very capable and long experienced attorney by the name of Patty Palmer Gezzi, who was an assistant federal defender in Oklahoma City, took up the case. And she continued to push that case along. Eventually, the case got traction in the Eastern District of Oklahoma. And while Judge White ruled against all the claims, he did certify one claim to go to the 10th Circuit, and that was on whether the Creek Nation reservation was disestablished or not. Judge White basically held that through the passage of time and the passage of statutes that the Muskogee Creek Nation had become so weakened that it ceased to be a reservation at statehood, and that there was no Indian country, and that therefore the grounds were not sufficient to set aside his conviction in federal court. It went to the 10th Circuit, and Patty Palmer Gezzi argued the case in the spring of 2017. It was done in the ceremonial courtroom, and the court actually granted the Muskogee Creek Nation and the Seminole Nation, of whom I was the Attorney General at the time, to also argue as amici curiae. And Kanji and Katzen law firm argued on behalf of those two nations as friend of the court. And I believe that there was another tribe, I believe the United Katuah Band, that also argued that supporting the Muskogee Creek Nation position. I remember at the arguments that several pointed questions were asked about, okay, which statute exactly disestablished the reservation? And the Assistant Attorney General for the state of Oklahoma at the time, I believe it was Jennifer Crabb, said, I can't point to a specific statute or a specific time that happened, but it got disestablished through the course of time. At that time, I thought that maybe Oklahoma had lost the case, and Mr. Murphy might have a shot at prevailing. And lo and behold, on August 7th of 2017, the U.S. Court of Appeals issued its 126-page slip opinion in Murphy versus Royal. And it held after going through all the treaties and statutes that were applicable, and the Anti-Terrorism and Death Penalty Assistance Act in 1996 and other habeas statutes, that indeed the Muscogee Creek Nation remained intact and that Mr. Murphy's conviction in the state court must be set aside. But that didn't mean that he would go free. It simply meant that Oklahoma didn't have jurisdiction over that crime and that he must be retried under the Major Crimes Act by the U.S. Department of Justice. So Oklahoma asked for rehearing on that case. They circulated the petition en banc to all the active sitting judges. No judge sought to have it reconsidered, and Chief Judge Tempkovich, who sat on the panel, wrote a special concurrence suggesting that they faithfully applied the precedent in Sutherland versus Bartlett and in Nebraska versus Parker to find that Congress had never explicitly disestablished the Muscogee Creek Reservation. But the practical import of this case was so significant because it could potentially involve half of Oklahoma and all of eastern Oklahoma that the Supreme Court should consider granting certiorari review. And sure enough, a number of months later, the U.S. Supreme Court granted certiorari and set the case for argument. The case came on for argument in, I believe it was 2018, if I recall correctly, November 27th or so, shortly after Thanksgiving. And again, there was amici participation, which was unusual. Riaz Kanji argued on behalf of the Muscogee Creek Nation as amici. The United States was asked to brief as well. Ed Needler, the longtime judge of the longtime Solicitor General who handles Indian country matters and has probably argued more than 100 cases before the Supreme Court. Truly a dean of the Indian law jurisprudence in the Supreme Court, also argued on behalf of the United States interests. And Lisa Blatt, who was a very prominent Supreme Court oralist, advocate, who was at Arnold and Porter at the time, argued on behalf of Oklahoma. She has a really incredible win-loss rate. At the time, I believe it was 33 wins before the U.S. Supreme Court and only 3 losses. And Oklahoma reportedly paid her firm a flat fee of $500,000 to take on its interest and to write the brief and argue the case before the Supreme Court. There were a lot of fireworks at the argument. I attended, and I can tell you that Justice Sotomayor and Justice Kagan in particular asked pretty pointed questions of Ms. Blatt during the arguments. And there were exchanges to the effect that I remember that Ms. Blatt said that Justice Kagan was fundamentally wrong and factually wrong in her questions and her positions, which Justice Kagan was a little bit taken aback and retorted back about that. And then there were fire exchanges with Justice Sotomayor, in which Justice Sotomayor asked Ms. Blatt, point to us exactly when Congress disestablished the Creek Nation and what statute did it do it with. And Ms. Blatt said, I don't have to show you that. And basically, it happened over a period of time. Rome wasn't sacked in a day. Things of that nature. It was a pretty fiery exchange. It was like a few exchanges I've seen in the Supreme Court. Riaz Kanji argued very eloquently about the Muscogee Creek Nation's interests during the argument and talked about cross-deputization agreements, the cooperative efforts that Oklahoma has had with the Creek Nation and back and forth in crafting, for example, cross-deputization agreements between local law enforcement, state law enforcement, county sheriffs, and so forth with the Muscogee Creek Nation. And at that time, they had 40 out of 44 jurisdictions under agreement. And they worked together on tobacco, on tax agreements, license plates, school issues, and the like. And it's a powerful way to deal with issues of common interest between the tribe and the state. So just about 10 days after that argument, the Supreme Court did something very unusual. They asked for additional briefing. They asked if Oklahoma and the parties could brief the issue of whether the Creek Nation, or whether Indian country still existed, and whether certain criminal statutes would apply regardless of whether there is a reservation or not, certain Oklahoma statutes. So that was an unusual wrinkle. There was no decision. Time went by, February, March, April, May, June. Everybody in Indian country was waiting with bated breath to see what was going to happen with Murphy versus Royal, and which had become Sharp versus Murphy by that time, with the substitute of another warden. And on the last day of when they announced decisions, Chief Justice Roberts announced from the bench that they were setting Murphy for re-argument in the summer of 2019, which was really unusual. And a lot of people were speculating, why did that happen? And so time went by. There were no additional briefings ordered by the court. And a lot of speculation started to happen. I wrote an article for the Federal Lawyer that was called "Has the Earth Shattered Under Oklahoma? Predictions and Implications of Sharp versus Murphy and McGirt versus Oklahoma," trying to figure out why the Supreme Court set up for re-argument. The most obvious thing that came to light later was that Justice Gorsuch had come to the court and had recused himself. So it was obvious that there was probably an 8-8 or a 4-4 split, which would mean by custom that the lower court decision would stand. Murphy versus Royal would be the law of the land. And that the interests within the Supreme Court were so monumental that they wanted to either have re-argument or find another case that they could accept certiorari on. Lo and behold, just about a month later, in December of 2019, the U.S. Supreme Court granted certiorari on McGirt. Jim C. McGirt was is a Seminole citizen, and he and his wife lived in Broken Arrow, Oklahoma, a suburb of Tulsa. And he was accused of and convicted of sexually molesting his 4-year-old granddaughter. And he was tried and convicted. And from what I've seen from reports, he was previously convicted of sexual molestation several times before. The Tulsa County jury found him guilty, and he was a sentence of life in prison, plus 1,000 years was meted out upon him for his conviction. In the wake of Murphy versus Royal, he mounted a habeas challenge and appealed, and it went up through the system, and it was one of the companion cases that the Supreme Court granted cert on. But in that case, Justice Gorsuch did not recuse, and there was no conflict, presumably because Justice Gorsuch participated on one of the multiple habeas appeals that went up before the 10th Circuit in Murphy. So that case pended. It was briefed. It was at issue as of late February of 2020. And then COVID hit in March. And that, of course, created all kinds of topsy-turvy for courts, and the U.S. Supreme Court was no exception. They continued the argument and postponed it. It was originally scheduled for late April. I was scheduled to go to that one, and then they rescheduled it, and they did it by teleconference. And for the first time in the court's history, they did a live media broadcast of the arguments, which was really unusual. One thing I was going to mention about ordering re-argument in Murphy, there have only been 4 or 5 cases that I'm aware of in the modern history of the Supreme Court in which they've asked for re-argument. Monumental cases such as Brown versus the Board of Education that involved racial equality in schools and busing. That was a landmark case. The Roe versus Wade case from the early 1970s that dealt with a woman's right to privacy and abortion. And also the Citizens United case from, I believe it was 2010, that dealt with campaign finance. Those are examples of cases that were set for re-argument and ultimately that were decided later. So when the case was ultimately argued, they did it by way of seniority, and Justice Thomas was the first one out of the gate. And he could go a number of years without even asking questions, but with this new format, they went by seniority, and he was the first one to ask. And Justice Thomas was very important to the argument because he wrote the Nebraska versus Parker case, which was a per curiam decision from, I believe it's 2016, 3 terms ago, that dealt with whether the Omaha Winnebago reservation was disestablished or not. And it set forth the test that the Supreme Court applied. And it was very important in the McGirt case. And under Parker, it seemed like a slam dunk. So everybody was watching to see what Justice Thomas would have to say about it. And he tried to distance himself in his questioning from the Parker case, claiming that, well, wasn't that just surplus land? Oklahoma's a whole different situation. It involves half the state, 1.7 million people, 1.8 million people, and much different considerations. The metropolitan city of Tulsa is involved. But you could tell from the arguments that a number of justices, including Justice Gorsuch, were focusing on the text and whether there was a specific statute from Congress that said Creek Nation is hereby disestablished, using language that's the hallmark of disestablishment. And nobody could point to that. So Indian country was really the focus of the cases. And Indian country, again, is codified in 18 United States Code, Section 1151. And basically, it's a 1948 criminal statute that took cases from the early 1900s, including United States versus Sandoval, United States versus Pelican, United States versus Ramsey, and others, and put it into an Indian country statute that said that if things happen on a reservation, on a dependent Indian community, or on allotments, trust lands, then federal jurisdiction lies, and it's exclusive for major crimes. It's been used as a benchmark for civil practice as well, both by Indian tribes and federal courts to demarcate that as of land, Indian country matters. So this was a very important case that could have a huge ramification. I wanted to show a chart. Basically, this is a chart. I don't know if I hold it up well here, of Oklahoma from about 1890, Indian Territory. And you can see the colored portions, the green, the blue, the red, the yellow, are the 5 tribes, the Creek, Cherokee, Choctaw, Chickasaw, Seminole, Cherokee nations. And those were the treaty reservation areas from the 1866 treaties. After statehood, of course, the popular belief was that by state officials that Indian country ceased to exist in Oklahoma, and that the statehood acts and other acts relative to statehood abolished reservations, essentially. Now, there's a lot of dissent within Indian scholarship and practitioners since then, and there have been a lot of cases fought about that, including a case from 1978 called State versus Little Chief, which was the first modern case that a federal judge in Oklahoma found that a allotment was Indian country, and that the murder that happened there had to be tried in federal court, not state court. The Oklahoma Court of Criminal Appeals, for the first time, took that unpublished decision from the Western District of Oklahoma and attached it to their decision dismissing the case, and it published it. And that created a vibrancy in Oklahoma for the modern era of tribal courts and the reestablishment and revitalization of many tribal courts across the country. And in Oklahoma, courts of Indian offenses were established. The Sac and Fox Nation established its independent court system. The Cherokee and the Muskogee Creek revitalized their court systems. And that was certainly a watershed case that served to change Oklahoma's view that it had jurisdiction over crimes that happened in Indian country within Oklahoma. One notable issue was the Oklahoma, during the termination era, during the 1950s, actually submitted comments to Congress claiming that it did not need to comply with Public Law 280 because for retrocession of jurisdiction, because Oklahoma believed that all reservations were abolished in the state, that therefore it didn't need to go through Public Law 280. And as we know, as Indian law practitioners, with the Indian Civil Rights Act of 1968, the law was amended so that the states would have to seek the consent of tribes before they could assume jurisdiction under Public Law 280, and that's currently the law. Since 1968, there's been no assumption of jurisdiction by tribes that I'm aware of. But why did McGirt and Murphy challenge their convictions? Because they wanted to be tried in federal court instead of state court. And for them, they had very little to lose. For Mr. Murphy, he was sentenced to death, and if he was tried in federal court, the worst thing that could happen would be that he would face a life sentence if he was retried and convicted in federal court. And for Mr. McGirt, perhaps he could roll the dice too. And I can tell you that in the wake of McGirt, the U.S. government picked up his case, put a detainer on him, and just after the election, Mr. McGirt was tried in federal court in Muskogee and was convicted again, except his 4-year-old victim in the case was now, I believe, about 26 years old, and she testified bravely against him, and he was convicted on retrial in federal court. So that is one important lesson of both McGirt and Murphy, is that it's not a get out of jail free card for serious criminals and violent offenders. It's simply a reallocation of jurisdiction. And it means that more cases will be tried by federal prosecutors in the Northern District of Oklahoma. And the FBI has been on a hiring spree. The Northern District of Oklahoma is hiring 2 new magistrate judges. They brought in over 30 different assistant U.S. attorneys and legal assistants from different jurisdictions around the country to help with the backlog. But it's business as usual in terms of law enforcement. It's just a matter of first responders will continue to respond, but it may matter who will prosecute cases. Minor offenses involving Native Americans that happen within the Creek Nation will be prosecuted by the Creek Nation. And there's concurrent jurisdiction over crimes. If there's a major crime, the Creek Nation could choose to prosecute a Creek citizen or another Indian that commits a crime within the reservation, as well as the federal government. The limits of the Indian Civil Rights Act are that there's a limit on the amount of fines or confinement that can be imposed by the Creek Nation courts. So Arvo Nikkanen, the longtime Assistant U.S. Attorney from the Western District of Oklahoma, has published a really wonderful chart that's available on the internet. I know that I put it on the Cherokee Nation Supreme Court website for the speech that I gave there. It's a two-page chart. It's very well done. It goes through Indian offenders. If the victim is Indian, if the victim's non-Indian, if it's a victimless crime, and other considerations to determine who prosecutes and what laws would apply. And it's a very helpful cheat sheet, but it can get very complex on how all that comes together. I wanted to mention a couple of things about civil jurisdiction in the wake of McGirt and criminal jurisdiction. There's been a lot of misinformation. There was a parade of horribles that was expressed by some of the advocates in both McGirt and in Murphy, that the sky would fall, that thousands of inmates would have their sentences vacated and re-examined. And I think we've seen through the test of time that that's not happened, and that criminal justice is being administrated as it was, just under different authorities. I wanted to mention that there are some cases that still stand, such as Montana versus United States. It's a 1981 U.S. Supreme Court case that governs tribal authority to regulate non-members and non-Indians on reservations. And it articulated a presumption that tribes lack civil jurisdiction over non-Indians and non-members, except under certain limited circumstances involving economic security, health and welfare, and issues of emergency like that. But so far, the Supreme Court has subsequently examined Montana versus United States in a number of cases, has not really found any of those exceptions so far under the exceptions under Montana. That's one guiding principle that the courts will look at in the wake of McGirt and looking at civil issues. One other thing I wanted to mention, the decision lineup was pretty interesting. Again, that was Justice Gorsuch who wrote the opinion. Justice Breyer, Justice Ginsburg, Justice Sotomayor, Justice Kagan were in the majority, and the minority was Chief Justice Roberts, Alito, Kavanaugh, and Justice Thomas, who also wrote a short dissent in McGirt. And I want to talk about just real quickly that Chief Justice Roberts was in the majority of 52 out of 54 cases this past term. And as Chief Justice, whenever he's in the majority, he has the custom of being able to assign the opinion. But if he's not in the majority, then the senior justice by custom gets to assign the opinion. And Justice Roberts wrote the long dissent in McGirt. And that is one of the rare dissents in which Chief Justice Roberts was not in the majority. A couple of takeaways from the McGirt case that I'd like to touch upon is that it's a new era in federal Indian law, and treaties do matter. They are the law of the land, and they stand as a higher level above statutes in the U.S. Constitution. Indian tribes are mentioned in the U.S. Constitution 3 times, and so frequently cases will make it up to the U.S. Supreme Court. And another important treaty case that came up last term was Wyoming versus Herrera, which was a hunting rights case on federal lands that turned on a treaty interpretation. And they overturned and recognized overturning a long-standing case called Ward versus Racehorse that had been there for over a century. But in that case, Justice Gorsuch participated and wrote some things to the effect that the treaties are very important, that the text matters. Now, Justice Gorsuch's participation on the Supreme Court highlights a judicial philosophy that's gaining much traction in the recent decades, and that's called contextual.
Hey, Mike, I just want to make sure we've got ample time for Q&A. I just want to jump in there. Sorry.
Yes, I think I've got 2 more minutes on the clock here, and I am watching the time. But one thing that McGirt really rejected was extra-textualism, and that is that you look at things outside of the treaty, outside the statute, such as the demographics in Tulsa, the way that things have changed since the statute. So I think originalism and textualism will continue to be very important in the Supreme Court. One issue to consider is tax issues. Oklahoma Tax Commission versus Sac-and-Fox Nation was a case that was decided by the Supreme Court in 1993. And it was one of those cases that for the first time brought up the term informal reservation in Oklahoma, which was an unusual term that I'd never seen in the Supreme Court jurisprudence before. But one other holding in Sac-and-Fox, and it was the license plate case that reaffirmed the right of tribes to raise taxes and register cars exclusively instead of having to comply with Oklahoma's license plate requirement. But it also stood for the proposition that Native Americans that work on the reservation and work for the tribe could be exempt from state income taxes. And that is an exemption, a longstanding exemption that we will continue to see, I think, in the wake of McGirt. But with the budget shortfalls, I think that revenue is going to be very important, not only for the state of Oklahoma, but also for the various nations, including the Creek Nation, to come to agreements on raising revenue on issues such as that. Also, I mentioned the Constitution, mentioning Indian tribes 3 times. One of those provisions is the Indian Commerce Clause. And that means that Congress, under Supreme Court interpretation, has the power to write laws that impact tribes, including restrict or expand sovereignty. And so that's something that tribes need to be very cautious about and watch in this era, because Congress could, by the stroke of a pen, change the dynamics, including the holdings of McGirt, through a congressional bill. We saw that happen in 2005 with a transportation bill that involved environmental issues, the so-called Midnight Rider that reportedly Senator Emhoff's office inserted into a must-pass omnibus transportation bill. And that could happen again. Tribes need to be cognizant and aware and vigilant of what's happening in Congress and protect tribal sovereign rights with those happening. Finally, and in closing, I just want to mention that in the wake of the closing of the Trump presidency, Justice Amy Coney Barrett was confirmed on the Supreme Court with the passing of Justice Ginsburg. And that could change the 5-4 balance that we've seen on some Supreme Court cases We don't know much about Justice Barrett. There's scant Indian law jurisprudence on her short time on the Seventh Circuit Court of Appeals. And it was not an issue of scholarship for her at Notre Dame. So it remains to be seen how she will rule on Indian law cases, but tribes should also be cautious about Supreme Court jurisprudence. And with that, I want to thank Sage for the opportunity to address you again. And I hope that in 2021, COVID abates and that we will be in a position where we can once again convene together in person. Wado, thank you.
Thank you so much, Mr. McBride. That was very informative and great information. Up next, we have Jonadev Chaudhary. He serves as ambassador for the Muskogee Creek Nation. Ambassador Chaudhary has extensive experience representing tribal nations, tribal citizens, corporations, and individual clients on issues relating to commercial litigation, gaming, governance, tribal sovereignty, and self-determination. Having spent his entire career serving tribal nations and native communities in various policy, legal, and judicial capacities, he possesses a deep understanding of the connection between the development of strong governmental institutions and tribal self-determination. In 2013, President Barack Obama designated Ambassador Chaudhary to serve as acting chairman of the National Indian Gaming Commission. He was then nominated by President Obama and unanimously confirmed by the U.S. Senate in 2015. During his tenure as chairman, Ambassador oversaw the $32.4 billion Indian gaming industry, comprised of approximately 500 gaming facilities operated by 244 tribal nations across 29 states. And we are very lucky and honored to have the ambassador joining us today. So with that, I'll go ahead and turn it over to you, Ambassador.
Well, Mado Jay, and Mado to Sage as an organization for putting this incredible event together. We've got the deepest respect for Sage. I've had the honor to work with many of the folks who are on this call and involved in Sage in different positions that I've served in the past. So deepest appreciation. And just to be clear, I'm here in my ambassador capacity today, which is a position that was created by Creek Nation as a return to its sovereign roots before statehood and other countervening events kind of derailed our sovereign authority. We used to engage in regular nation-to-nation diplomacy with the United States as well as other European nations, and we'd have formal emissaries and ambassadors, and that fell off the map in the early 1900s, and I'm very honored to be part of a return to that tradition. The Muskogee Creek Nation's creation of the ambassador position is significant when looked at in a historical context. And that historical context is what I want to talk about today as a backdrop to the decision, but it's also important in terms of understanding what Creek Nation is doing today. And so I'm not going to get into the legal nitty gritty. And even though I do sometimes wear a lawyer hat in my ambassador capacity, I don't function as an attorney. I function as a spokesperson for the leadership of my nation, and that's the capacity that I'm in. Now, I do appreciate Mr. McBride's very eloquent explanation of the torturous procedural history that ran through the Murphy litigation and all the procedural hurdles that went that the parties went through there, and how it morphed into the McGirt litigation. And that long, torturous history, I appreciate that walkthrough. I felt like I relived it there in some ways. And there's a little bit of PTSD as somebody who, like so many of us, watched each of those decision points get made and watched the case get pushed back and watched the drama build. And drama there was. The sky is falling narratives were plentiful. The rhetoric was high leading up to the Murphy and McGirt decisions. But what's notable is they've continued, and they've continued since those decisions came out, and they've continued for the purpose of trying to push for, frankly, unnecessary and unhelpful legislation. But anybody who's followed Indian law and policy, anybody who's studied it, and certainly anybody who lives in Indian country knows there's nothing new about sky is falling narratives preceding bad policy. And we've seen it happen all too often in Indian country. Mike mentioned the Little Chief case, and I think it was 1978, that ultimately led to the courts of Indian offenses being developed in Oklahoma. Well, that case came out at a time when tribes really hadn't been supported in their capacity to build tribal court systems because there had been a wrong misperception that tribes didn't have the authority to have tribal courts in Western Oklahoma. The Little Chief case came out and proved that to be untrue. Indian country banded together, the Indian law community banded together and made things work in Western Oklahoma. That's kind of where we're at right now with McGirt. I'll get into what we're doing on the ground, but Creek Nation squarely sees the decision as on par with Brown versus Board of Education, on par with these watershed decisions. And the decision is truly an opportunity to prosper. This is something that was embraced, not just throughout Indian country, but among indigenous communities throughout the world. We had calls from New Zealand, from indigenous communities in Asia, indigenous communities in South America, the day of the decision. This is truly a global moment. But beyond indigenous communities, this is also an opportunity for non-native communities to prosper. Anybody who's seen economic development in Indian country and the opportunities there are to work hand in hand with tribes for joint economic development understands that if we work together, and this will benefit everybody, and it'll certainly benefit everybody on a public safety level. Whereas the case involves simply crimes committed by Native Americans, which is one subset of the larger criminal landscape in any community. Those cases before the McGirt decision could only be prosecuted, or were only being prosecuted, by Oklahoma, and in many cases not very effectively. Now, after the case, we have the United States and Muskogee Creek Nation on our reservation fully recognized as having the authority to prosecute these cases. So a lot of sky is falling narratives played into the public safety aspect of this. But to be clear, after this decision, there are two superpowers, the Creek Nation and the United States, that can go after bad guys. So this is the case was a bad day for bad guys. And as Mike pointed out, yes, the individual claimants in the case, McGirt and Murphy by name, were pursuing remedies on their own right. Overall, first, it's important to notice that they're being prosecuted on the federal level. But overall, now there are just more resources and tools available to go after bad guys in these areas. And that's what brings me to SAGE. Let me just say, our efforts at Creek Nation from day one have been to build on our history of intergovernmental cooperation. As Mike pointed out, before the decision was issued, we already had well over 40 intergovernmental agreements with our sister sovereigns, whether they were county, local, or state, and in some cases, the federal government. We have just built on that, and we built on it in a formal way. After the decision, our Principal Chief David Hill, formed the Muskogee Reservation Preservation or Protection Commission. And that commission is comprised of, I think, 44 of our best and brightest at Creek Nation. And we have two charges in that commission. One, to look inwardly at our governmental operations, to explore all reasonable avenues for responsibly building into the sovereignty that was affirmed by this historic decision. But second, and probably just as important, the commission is charged with the responsibility to look at opportunities to work with other sovereign entities, work with other governmental entities, whether it's the federal government, the state, or the county or cities, to work on building on this framework of intergovernmental agreements so that we can build a better future together. That's what's being done. And Creek Nation is putting its own very, very scarce resources into this. Just recently, National Council authorized yet another expenditure of over $2 million. And we all know in Indian country how hard resources are to come by. But over that $2 million has been going towards ramping up law enforcement, judges, prosecutors, defenders, and social workers. Now, this is important. That ramping up just adds to the protective framework that exists within Creek Nation. Keep in mind, all these skies falling narratives aside, there's no more criminal activity than the day after McGirt than there was before. In other words, you have the same number of people, you have bad actors doing whatever they're going to do anyway. The only thing that's changed is who gets to go after the bad guys. And now, with the addition of this additional, injection of judges and prosecutors and defenders, you have more people going after bad guys and keeping people safe in our community than ever before. And that's just on the public safety side of things. There have been many strong points made by advocates for safety of women generally and safety of Native women, who point out that the historical trajectory of policy has been toward capacity building of tribal nations so that we can protect our women, we can build our court systems, build our governments. The trajectory has been going upward, as evidenced by VAWA's 2013 reauthorization, as evidenced by the Tribal Law and Order Act, TLOA, and all these steps towards building capacity so that tribal nations, as a matter of local decision-making, local problem solving, can protect people on the ground, protect natives and non-natives alike. This isn't the time to reverse that trajectory. And so this sky is falling narrative that, oh my goodness, criminals are gonna run loose, is actually very dangerous when you think about the first order of business should be building capacity both within the tribe as well as the federal government to protect people on the ground and to implement tools to allow us to work together in the civil arena to build a better future. That should be the focus of everybody's attention. And that's certainly the focus of the Muskogee Creek Nation Reservation Protection Commission. So a couple more points. The idea that we need to fix this case is something that's been floated by folks who frankly probably have an agenda that has nothing to do with public safety, probably have a financial agenda. We've made the point that Creek Nation, like so many nations, we're for responsible economic development. We're for responsible resource management. We're open for business, in other words. Rather than rushing towards legislation, everybody should be working together to explore opportunities to enter into cooperative agreements to benefit everybody. Now, I want to give a little historical background, and I often mention this. The Muskogee Creek Nation was the first nation to enter into a treaty with the United States after the ratification of the US Constitution as it's known today. And this is significant. This is significant because that treaty helped define the southeastern boundary of the US. It was later repudiated by many members of our tribe because of the large land cessions involved, but it did a very important thing for the US. It provided the US legitimacy on the world stage in the wake of the US Revolution, or the Revolutionary War, because sovereign nations engage in intergovernmental collaboration. And Creek Nation was there when the United States needed that legitimacy on a world stage. And we've been there at every stage. We have engaged in intergovernmental cooperation and collaboration all the way up to present day. Now, it is our hope that this intergovernmental collaboration continues in the wake of McGirt, but everybody on this call has an important role to play. Many of you are federal officials, federal employees, and I wish I could see everybody's faces because, you know, I've been honored to work with many of you. The Creek Nation is focusing on capacity building, relationship building, and protecting everybody in our borders. All governmental employees have a critical role to play in that. We had a meeting recently with the Attorney General of the United States, and it was actually a very positive meeting. We laid out our positions that the Creek Nation adamantly opposes any legislation that would in any way undermine the jurisdiction, sovereignty, or treaty rights of the affirmed in the historic Supreme Court decision. We pointed out that Indian country is uniformly against that as well. NCAI has issued statements on this, Association on American Indian Affairs, National Center for American Indian Economic Development, as well as MAST, USET, Great Plains, Intertribal Council of Arizona. If I'm missing any, please forgive me. But all the regional and national organizations have come out strongly saying, don't touch McGirt, just put it in a place similar to Brown versus Board of Education, and let's work on building a better future together. But if folks undermine capacity and instead say, oh, McGirt's a problem to be solved, let's even though the ink's not dry in the decision, let's pursue legislation to undermine it, then this historic win for Indian country, for non-natives in the United States, and frankly for indigenous communities throughout the world, risks being lost. And that's where government employees come in. You know, the opportunity to work together, whether or not somebody's working for a tribal government, a federal government, or a state government, are huge in the wake of McGirt. There are opportunities to explore jurisdictional strength that comes from a collaboration, and there are opportunities to kind of build together. And I don't know who in what office will be coming down with this position or that, but to the extent any of you that work with counterparts at the other governmental offices can simply say, hey, we've got a good relationship across the lines with our governmental partners. We have no doubt, we have every confidence to believe that whether it's public safety or civil matters, if we work together, good things will happen. And there are going to be conversations with career staff or with folks who work in various areas of operations. And just that message being, we have good relationships. Let's continue to build on them. Let's not have a rush to legislation. That would be very, very helpful. And that's why, from Creek Nation's perspective, we absolutely have longstanding respect for SAGE, and we think SAGE has a critical role to play in protecting this historic decision. Now, I do want to leave with kind of one thought. Even though in the lead up to the case, everybody thought treaty rights would be what everything hinged on. And as Mr. McBride mentioned, Justice Gorsuch's beautiful opinion upheld treaty rights. But we've made the point that in applying this line of cases, it's called the Solemn versus Bartlett line of cases, Nebraska versus Parker, you know, it's not just treaty rights that are protected. It's the notion that if Congress wants to diminish a reservation, it has to show its face to the world. And that has potential positive benefits to reservations, regardless of their history. That's a universal win for Indian country. And I think that's why tribes outside of Oklahoma and, you know, frankly, throughout all of Indian country understand the importance of preserving this important decision. And SAGE and governmental employees, we have a critical role to play in that, because our voice is such that we can say, with the support, the tribes can build capacity to address any and all issues here. And the federal government should build capacity to uphold its trust responsibilities to address safety issues in Indian country, as well as other civil issues. We have a voice in this, and I just thank you for all of your time. I appreciate all the continued good work SAGE does, as well as all of the people that are on this call. I'm really looking forward to a vibrant Q&A session. It's just an honor to join you all. Mado.
Thank you so much, Ambassador. Great overview and great insight. So it's time for the Q&A. The attendees, you're more than welcome to raise your hand if you'd like for your line to be unmuted and ask your question that way, or you can type into the Q&A box or the chat box. We do have a question in the Q&A box. This question says, the Supreme Court reversed the OCCA's decision in a 5-4 ruling. With today's makeup of the Supreme Court, do you think the outcome would be the same? And whoever, John Dev or Mr. McBride, feel free to jump in.
I think it comes down to Justice Barrett and what her jurisprudence is going to be. And also it comes down to considerations of stare decisis, which means respect for prior decisions that have been made by the Supreme Court. And it remains to be seen how Justice Barrett is going to come out on this.
I'd agree with that, and I would just say to Indian country, we shouldn't write off Justice Barrett. I mean, I know there is a lot of public dialogue around positions outside of Indian law, which public dialogue around her confirmation, and I understand that, but she really hasn't laid out a lot of positions in Indian law, and there's a lot of room for positive Indian law cases if you have kind of a textualist approach, or if you have, depending on where you're coming from. So I know there's going to be a lot of education among the judges and justices, and Justice Gorsuch, you read that decision, we have an intellectual heavyweight on our court who truly understands the foundational underpinnings of Indian law. The justices will be educating each other, and I know that it's hard to answer that, but I wouldn't just immediately assume that we've got an unfriendly court in Indian law right now. But time will tell. It's kind of a blank slate from the public record.
Okay, thank you so much. A question that came into the chat box is, the person says, I'm confused on why there would be a hiring frenzy by federal investigators as a result of the ruling. Can you provide more detail on what the anticipated roles for these investigators would be?
Well, if I could just take it briefly, as I said before, the McGirt ruling was based on the application of the Major Crimes Act to these two crimes in particular committed by Native Americans on the lands that we've always maintained were reservation lands. And in holding that the reservation was intact, the court did find that the Major Crimes Act did apply. And as part of that, Creek Nation also has concurrent jurisdiction. For reasons that would take a long time to go into, there's no double jeopardy problem with Creek Nation prosecuting the same crime as the U.S. Attorney's Office. So in other words, these cases that were the small but very important subset of cases involving crimes committed by natives on the reservation, Native Americans on the reservation, they're now clearly being committed on the reservation, and as such, they're subject to U.S. jurisdiction and Creek Nation. So the federal government does have a responsibility to uphold its trust responsibility in prosecuting those crimes. That's why I think the hiring moves are being made. But let me make one point about resources. Resources aren't policy, and they're not constitutional law. And so in the briefs that led up to the Murphy and McGirt decisions, the U.S. U.S. Attorney's offices, I'm sorry, not the U.S. Attorney's offices, the Department of Justice issued briefs pointing out how costly this exercise of federal jurisdiction will be. Well, there's an understanding that there's some cost to this, but those budget issues are just that. They're budget concerns, not necessarily jurisdictional, legal, constitutional concerns. Indian law, flows from, constitutional and pre-constitutional United States law, and flows from our status as pre-constitutional sovereigns. And so these budget issues, while they're important, they shouldn't trump the foundational jurisdictional underpinnings of Indian law.
Jay, I would just add that basically the Federal Bureau of Investigation in some instances will be additional first responders, and they're pretty thin. So that's why those investigators will be increased. But as Ambassador Chowdhury mentioned, there are a lot of cross-depth agreements out there. And so various first responders will investigate and take care of crises and emergencies when it comes to criminal law. But to adjudicate those under the Major Crimes Act in federal court, they do need more resources. And the federal court has really been ramping up to take care of that.
Great, thank you. And we have received a couple of questions regarding recordings of the video. So I just want everyone to know that a recording will be available for you to watch on demand later from the SAGE website. And we'll also send out a link to the video and additional resources to everyone who's registered to attend. So I had a question that says, I'm wondering what impact you see this having on tribal police power to regulate land use and have influence on zoning, housing, and economic development. Will our tribes be able to set up land use and zoning regulations and assert taxation authority?
Well, these are complicated issues. I mean, in holding how he did, and in holding how the court did, the court found that Creek Nation was Indian country under what's known as Part 1151, and under federal law. 1151 is a criminal, as part of the criminal code, but that definition of Indian country has been used for civil authority as well. But as Mr. McBride mentioned, there's a whole framework of limiting laws, whether it's US versus Montana or other limits that kind of define the limits of tribal authority in Indian country. And so a lot of this is kind of pretty straightforward, but it goes back to the work that the Creek Nations Commission is doing. We want to identify ways to kind of address these issues of civil regulation, taxation, what have you, in a cooperative way with the counties and the states, and frankly our other tribal sister nations. But you can't do that if there's a rush to legislation. And so a lot of this will kind of play out, but there's nothing scary here for non-natives. This all is an opportunity to kind of listen and work together to provide incentives for businesses to come in, improvement in utility, sewage, jobs. This is a good thing. We've seen this in a lot of industries outside of Oklahoma. If we just work together, all those implications provide opportunity.
I would just add two Supreme Court cases that would be relevant. First is Bracker versus White Mountain Apache Tribe, which provides for a balancing test when tribal governments and federal government interests versus a state government interest are asserted in Indian country. And so I think that we will see some Bracker cases out there balancing what those interests are and which prevail. The second case is a case from 1989 called Brindale versus the Confederated Tribes of the Yakima Reservation. And that was a zoning case. That was a pretty fractured opinion, but it was another post Montana case that dealt with the zoning. So I think the short answer is we don't know, but there are some tools out there. These cases can be difficult to adjudicate because they're very factually intensive or to do the balancing test, and they can take a lot of resources. But I might add that it's a great time to be a federal Indian lawyer.
Excellent, thank you. Here's a question we have. Have OIPA and Inhofe agreed in writing to not pursue legislation? Who exactly is on Capitol Hill advocating for tribes and monitoring to prevent another midnight rider?
So OIPA, that may be a reference, and my apologies if I'm missing OIPA, but there was a statement issued by OCPA, which was the Oklahoma Council on Public Affairs, who basically called for disestablishment of reservations in Oklahoma. There's been also unfortunate saber rattling from some, leaders who frankly serve in very high positions, calling for either disestablishment or legislation that leads to kind of PL 280 results. A lot of folks have been very vocal on the Hill to make the case that even if you don't agree with us with Indian country, first and foremost, the Midnight Rider process is no way to handle these issues of profound issues of constitutional law that impact the relationships between tribal nations and the United States. The Midnight Rider process is not, that's the wrong place to conduct Indian law. And so even folks who aren't necessarily on the side of Indian country on various sovereignty issues understand, given the gravity of these issues, process-wise, the Midnight Rider is not an appropriate process. But that said, you still have to be vigilant at all stages. And at least Creek Nation has been doing everything it can to make the point that not only is there no problem to be fixed, all effort should be put towards capacity building and supporting governmental, supporting resources. That's the point we made to AG Barr. That's the point we make to every member on the Hill. Let's roll up our sleeves and figure out how to build capacity for tribes as well as the federal government to uphold its responsibility. If that involves institutionalizing funding through congressional appropriations, let's do that. So people are working on this, but doesn't mean we shouldn't be vigilant every step of the way.
Great, thank you.
Yeah, I would just add that it is important to be vigilant, and there are advocacy groups in Washington look after Native interests, such as the National Congress of American Indians. And certainly tribes are active. Ambassador Chowdhury is on the ground in Virginia.
Yep.
But I think that cooperation and making the case is important, and that everyone should avoid extremism. These real hard and fast solutions like that can be very extreme, and I just don't think that's in everybody's best interest.
And thank you. I see somebody kind of pointed out OIPA's Oklahoma Independent Producers Association. Mado, for that clarification. To my knowledge, nobody's come out and said let's see, OCPA and none of these other folks who have pushed for legislation, nobody's come out and said we're not going to call for legislation, which is unfortunate. I mean, this is a time to celebrate and work together.
Great, thank you. Question, do either of you have comments about the decision by US EPA to allow Oklahoma to continue environmental regulatory program administration on the reservation?
I'll try and be quick. So back to this Midnight Rider. I think Mr. McBride already mentioned it. In 2005, there was a Midnight Rider called the Safety Act, massive transportation bill, over 12,000 sections in it. In one section in the 11,000 range, you had two paragraphs snuck in that basically set aside Oklahoma tribes separately from tribes anywhere else in the nation, and basically said that if the state requests it, the state can be granted from EPA the authority to apply an EPA regulatory power on Indian lands and Indian country. And it's very unusual. Usually the relationships between tribes and the federal government is nation to nation. In this one rider, it created this avenue for a state to request the authority from the Environmental Protection Agency. And that was bad enough, but it created a category of tribes in Oklahoma different than anywhere else, because in order for tribes to request treatment as a state, which most tribes can do outside of Oklahoma without without running it through the state, the only way you do that in Oklahoma now after that Midnight Rider is to get an agreement from the state that that's okay. So it was very concerning that this major act was snuck in to this massive transportation bill. But as bad as it was, it had never been exercised by the state of Oklahoma until the McGirt decision came out. And unfortunately, in light of the decision, we don't know if it was retaliatory or what the thinking was. Governor Stitt did request that authority, and the EPA Administrator Wheeler granted the governor's request. So I think tribes are in the various stages of trying to assess what their options are given this unique Midnight Rider and the granting of authority under under the Safety Act.
I would just add that it was a political decision, and there's a change in administration, and there could be a different interpretation of what happened in October from the Environmental Protection Agency.
Great, thank you. And Ambassador, I know you had mentioned, all the various relationships that Muskogee Creek Nation has with different government entities. How's that relationship been with the local municipal governments? Has the nation been working with like City of Tulsa on these issues?
Yeah, and I don't want to kind of highlight who's been good, who's been bad, but I let me just say, for the most part, great, but in some cases mixed. And so I think rather than calling for legislative fixes or anything, folks in power could use the bully pulpit of their offices to encourage on-the-ground cooperation. And so what I mean by that is, unfortunately, there have been some very high-profile matters that have involved transfer of cases or, lack of clarity about who had authority, where one or two prisoners have been kind of let go without ensuring that they're immediately prosecuted by a sister jurisdiction. Now, all of those have been addressed, and all of these were understandable given the, whenever you have a historic decision, that's kind of, that there's a lot of transition that goes into that. And we saw that with Brown versus Board of Education and onward. But once you dug into it, all of these matters could have been addressed had the local jurisdictions just reached out to Creek Nation. And so I don't want to throw any specific jurisdictions under the bus, but for the most part, all of our partners are committed to the orderly transfer of cases, the orderly investigation of cases, and there's the power to detain and investigate that can be worked out throughout any legislation whatsoever. We're committed to doing that, but Creek Nation can only do its part. And so we would hope that other leaders, just like our chief has done, use the power of their bully pulpit to encourage on the ground cooperation. So I do want to say we've got a great relationship with almost all the mayors. Certainly again, I don't want to go into specifics, but the relationships are good, but there have been some unfortunate situations where if a local sheriff's office or a local DA's office had just coordinated with us, things, I mean, we all took the same oaths. All of our law enforcement officers took the same oaths to protect the public. And we'd expect everybody to uphold those oaths in the same manner that we're committed to. But overall, the relationships have been good.
Great. Excellent. Well, thank you all so much. This ends our webinar for today. And we certainly appreciate all the attendees for joining us today and hope it was helpful and beneficial. As I said, this recording will be available for you to look at again later. And then I want to extend a very special thanks to the ambassador for joining us today and to Mr. McBride for taking the time to prepare and give us all this great information. So thank you both very much, and look forward to seeing y'all again at another SAGE event in the future, hopefully in person.
And just Mado, and for folks, I see several names I remember from back in the day. Just good to see everyone. It's truly been a pleasure. Mado, for the opportunity.
Thank you.
Likewise.
Bye, y'all.